Presiding Justice Madlanga, I do believe that all parties are online. May I ask the Registrar Clerk to call the case with your leave?
Yes, Justice Ron.
You're on mute, ma'am. Yeah.
Good morning. I'm the Registrar Clerk for this hearing. Justices of the Constitutional Court, all counsel are online. I call the matter of Union for Police, Security and Corrections Organization and South African Custodial Management Pty Limited and others for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Thank you, Justice Madlanga and Justices of the Constitutional Court. I'm Shonisani Ravele for the applicant.
Thank you, Mr. Ravele.
May it please you, Justices, together with my learned friend, Mr. Edskin, I appear for the respondents.
Thank you, Mr. Mutau. Yes, Mr. Ravele.
Thank you.
You have your 10 minutes. Go on.
Thank you, Justice Madlanga and the Justices of the Constitutional Court. And may it please the court, it could never have been complemented by the drafters of the Constitution that in a constitutional democracy, employers who are tasked with administering sentences passed by our Constitution on behalf of our government and contribute in maintaining and protecting a just and peaceful and safe society will refuse to comply with the task team finding of the Department of Correctional Service, directing them to pay the workers' pension benefits similar to the state counterparts, and proceed to deny the workers' rights to assemble and workers' right in section 23 and 21 by refusing the union access to the workplace based on the forceful statement that the organizational right agreement is cancelled, when the employers were fully aware that the agreement was effective until March 2018. We submit that had the drafters of the Constitution foreseen that perhaps they will have required a national legislation that should be enacted to give effect to the rights in section 17, 23, and 22. The simple no requirement made in section 17 and 3 that require national legislation to be effected to give these rights to be enacted. Thus, the applicant's decision to shift its claim at the High Court to the Constitution and common law makes sense, as the relief that the applicant is seeking is not covered by LRA or patchwork of other statutes. We respectfully submit that perhaps the legislator will expressly have done so by establishing the statutory scheme for claim arising from such failure to supersede the existing common law, for example, what they did in the Road Exempt Fund and the CODIA Act, and the course of action or remedies available in section 157 of the LRI in order to cater the litigants like the applicant and its members so that they can pursue the appropriate and effective remedy in the circumstances. Hence, section 38 and section 172B of the Constitution demand that the applicant, if they are able to show that the right in the bill has been infringed, the court may grant an appropriate relief to vindicate the constitutional right that has been breached. So we will submit that after the respondent accepted that particulars of claim, the High Court, in holding that the applicant in its particulars of claim to challenge the constitutional validity, either the LRA or Section 12, the principle of subsidiarity required that the applicant should do so, and that the applicant was unable to attribute any definitive meaning to the impugned statement, we submit the High Court made fundamental errors which required this court to intervene and set aside the court order upholding the exception with cause. We will demonstrate that the principle of subsidiarity doesn't apply in this case, and the gap is filled by the application of constitutional provision and common law. So in my address, Justices, I will deal with the following issues. I will first deal with the issue with regard to the leave to appeal and the jurisdiction, and I will also deal with the issue whether the principle of subsidiarity applied in this matter. And then I will deal with the issue whether the impugned statement is defamatory. And then I will also deal with the hearing of two interlocutory applications containing the same issue. And then lastly, I will deal with the issue of the cost order made by the High Court and the Supreme Court of Appeal. I will therefore proceed, Justices, to deal with the issue pertaining to jurisdiction and leave to appeal. Justices will note that the respondents up to this stage are contending that this matter doesn't raise a constitutional issue or arguable point of law of general importance. They submit that because the applicant sought refuge in the Constitution instead of seeking refuge in Section 12 of the Labor Relations Act, there's no constitutional issue that is being raised. We submit that this is wrong. This matter engaged the jurisdiction of this honorable court because it raises constitutional matter and it also raises arguable point of law of general importance. Then we submit that this matter raises an important constitutional issue which involves the right to fair labor practice, right to assemble, and it also requires the court to consider whether there's any provision which advance those rights. This court in Havas at paragraph 33 held that exercise of right to assemble in terms of Section 17 of the Constitution by the trade union and other organization is a constitutional issue. We therefore submit that this matter also implicates on Section 72 and 38 of the Constitution. And we submit that having regard to the applicant's funding affidavit in this court and the particular claim, the applicant is advancing constitutional issue and arguable points of public importance. So I will then proceed to deal with the issue why we submit that the principle of subsidiarity does not apply in this matter. We submit that the High Court, in finding that the principle of subsidiarity is applicable in this case, it relies heavily in the decision of this court in Sandu. Then we submit that Sandu principle and provision are not applicable to the facts of this case. We say so because the Sandu principle and provision are aimed at preventing a litigant to circumvent the legislation and relying directly on the Constitution, thereby undermining the constitutional enshrined role of the legislation. The applicant in this case does not seek to circumvent the Labor Relations Act or to undermine the constitutionality enshrined role of the legislator. The applicant does not seek to undermine the value of constitutional democracy. Instead, what the applicant sought to do at the High Court was to hold the respondents who we submit that they are organ of state because they perform public functions and statutory duties for their failure to grant the applicant access to court for purpose based on the false information that the organizational rights agreement was cancelled. We submit that if one look at the decision of Pretorius in this court, wherein Justice Frontman, writing for the majority in this court at paragraph 50, he made it clear that the application of principle of subsidiarity in Labor Relations Act and other labor legislation is very complex issue. For example, the Constitution in other instance, for example, right to access to information and just administrative actions, require national legislation to begin to give effect to those rights. The same requirement is not made in Section 23, and Labor Relations Act itself, however, set as one of those objects. Then he proceeded to say that nevertheless there are other pieces of legislation that are that also cover the aspect of potential unfair labor practice. And in paragraph 51, which we submit that the High Court ought to have taken cognizance of that, he proceeded.
Mr. Ravel?
Yes, please.
The 10 minutes is up. You may continue.
Yes, please. In paragraph 51, this court proceeded to say that the principle of subsidiarity was recently considered in my vote count. Neither the majority or the minority are direct on the point because the issue involved a provision of constitution that require parliament to act. Section 23 lacked that requirements, and a decision to parliament not to cover the entire field will not fail or fulfill the duty in the constitution. So we rely directly, and which we said in the High Court, that the proposition made by this court or the authority made by this court is that a fair labor claimant may be entitled to rely on the constitution directly without having sure that the Labor Relations Act or the patchwork is deficient. So we submit that the manner in which the High Court applied the principle of subsidiarity, it applied it as it's a hard and fast rule. And we submit that my vote count expressly disavows that. And it says that there are decisions in which this court has said that the principle may not apply, and this court is yet to develop to the point where the inner and the outer counter of its reach are clearly delineated. It is not
Mr. Ravel.
As a police justice, Tara.
Thank you. I'm sorry, ma'am.
Okay.
Please proceed, Justice Titi. Please proceed, my assistant.
Mr. Ravel, I'm interested in your earlier submission. You said that the applicant does not seek to undermine the Labor Relations Act. Do you recall that you said that?
I do, Justice Chigi.
Okay. What was the catalyst for the proceedings in the High Court? What led to those proceedings? Was it not the refusal to allow access to the workplace?
Yes, it was the refusal that led to that application, that action in the High Court.
And it also impacts collective bargaining.
We'll submit that the position is different here because this is not a case that is one.
No. I think let's take it step by step because I'm trying to understand your submission. So let's take it step by step. Does it or does it not impact collective bargaining?
We will submit that it doesn't, and then I will say so in this because in this instance, there's no dispute that there was already an organizational right agreement in place. And what the union was seeking was that we want to assemble, we want to exercise our right to assemble, whether inside or outside the employment. So I will just dispute.
I'm sorry to interrupt you. I'll keep on interrupting you because I want you to assist me. in understanding your submission. So am I wrong in thinking that the dispute was about a collective agreement?
Yes, I will submit so, because here the union is just making a request to say that we want to assemble. I will just think, for example, Justice Chiki, for example, the SRC requesting the Vice Chancellor at the university and say that we request a permission that we assemble. We want to discuss with the student the following issues. So the importance here is that there's a right to assemble, and wherein is quite clear that these people who want to assemble, they are not carrying any firearm or what, and then that right must be generously interpreted. So that's what led to the application for constitutional invalidity, especially with regard to section 17.
So the catalyst really concerned a refusal to access to the workplace, which is provided for in the Labor Relations Act. And it also involves a dispute about a collective agreement, which is also in the Labor Relations Act. Now, I don't understand when you say that you don't seek to undermine that, specifically in the light of what was said by this court in Sandu 3.
I will submit, Justice Chiki, that Sandu must, this matter is totally different with Sandu 3, because in Sandu, the right that was pleaded, it was 23.5. We pleaded the rights in 23.1 and 2. It's a union that is requiring to assemble with its member. So, and we say that the applicant did not want to engage in a collective bargaining under 25.3, nor with the respondents. Nowhere in the applicant particulars of claim, reliance is given to section 23.5. And 23.5 is important.
What is Sandu saying in paragraph 50? What is Sandu saying in paragraph 51? What does it say in paragraph 51?
If I can just have a Sandu with me. But while my colleague is assisting me, I will submit that Sandu must not be applied in the manner if one look at Sandu and Pretorius, for example, the rise that we are asserting is in 23.1, and we submit that and looking at Sandu at 51, where it says that section 23.5 expressly provides that legislation may be enacted to regulate collective bargaining. The question that arises is whether a litigant may bypass a legislation so enacted and rely on the Constitution. So I will say that this case is not Sandu. The rise that we are pleaded in the particulars of claim is 23.1 and 23.2 and right to assemble. So this will submit that the court should find that in this case, what was applicable is the rise that were pleaded in Pretorius. And I will therefore submit that this case is totally distinguishable from Sandu, and the proposition that we put is in Pretorius, where it says that a litigant must not can rely directly to the Constitution without even showing that the LRA is deficient.
Let's read section 23.5 of the Constitution. Every trade union, employers organization, and employer has the right to engage in collective bargaining. National legislation may be enacted to regulate collective bargaining, which is why I then asked you whether collective bargaining is implicated in this matter, and access to the workplace is impacted. So you're saying that it's not It's not related, or it doesn't relate to Section 23 of the Constitution. 23(5) of the Constitution.
I submit so, because even if one look at 23(1) and 23(5), the only difference that we see, which I will, for example, make it looking at 33, then is that in 23(1), there's no indication that a national legislation may be enacted. In 23(1).
But in 23(5), it does says national legislation may be enacted. And we know that, these sections that are read for you in the Labor Relations Act have been enacted for that purpose.
So I'll submit that when we do so, we must look at what 33 tell us and see if the drafter of the Constitution wanted to cover a situation that the applicant find themselves. For example, where they say in Section 33 of the Constitution, where they say that national legislation must be enacted. But if you look at Justice Chigi at 23(5), it says a national, the legislation may, it used the word may. So I'll submit that the use of word may is quite clear that the drafters of the Constitution were well aware that Labor Relations Act will not cover all instances. For example, the situation we're in this case, there is already an organizational right agreement in place. The High Court comes and says that you ought to have challenged Section 12. What Section 12 does, Justice Chiki, is just to enhance the right to fair labor practice in Section 23(1). So the union already had a right, and then even that organizational right agreement say that you can, the employer may not unreasonable withheld. And in this case, it was unreasonable withheld and with falsehood. And then let's take, for example, that the applicant, we are to accept that no, 23(5) is applicable. And then we said that the applicant must now must go to the CCMA. What will they go and do at the CCMA? Because you can only go there to seek for organizational right in 21. But CCMA will turn you down and say, look, what do you want here? Because you have the organizational right agreement in place. And then now there's no way, even if we look at the Labor Relations Act, we don't see what remedy the Labor Relations Act gives for anyone who has been unreasonable withheld a permission. And we submit that what the applicant is doing at the High Court is quite clear that their rights in 23 were infringed, and secondly, their rights to assemble was infringed. And we say that Sandu provision doesn't apply because this is not the case wherein the applicant pleaded 23(5).
Sister Verona, thank you very much for giving me the opportunity.
Thank you, my sister. Thank you.
Through you, Justice Madlanga.
Yes. Mr. Ravela, before I go to the question that I had, just to follow up on the questions that were posed to you by Justice Chikri. We're dealing with two claims by the applicant. The first one is founded in sections 17 and 23(1) and 23(2) of the Labor Relations Act. And the second claim is the defamation claim. Is that right?
I agree, Justice Taran.
So if the claim is founded in the Labor Relations Act, surely your remedy should lie there.
I didn't hear that properly.
If your claim, if the first claim is founded in the Labor Relations Act, surely your remedy should lie in that act or your recourse.
Yes, but then the applicant claim is founded in 23 and 17. It's not found in the provision of Labor Relations Act.
It's found in the Constitution.
Yes.
But isn't there relief provided for you in the Labor Relations Act?
I will submit that there's no relief in this instance, because in this case, the only relief that the union is recognized, it has rights, it has entered into a collective agreement, which is in place. And the only way that it can have a recourse is through 21, where in a union that want to be recognized so that it can have access, it can then enter the workplace. But in this case, it already enjoyed that rights, and that right has been unreasonably withheld based on falsehood, because we know that the organizational right agreement there was only a notice that was given in December, and that notice in terms of the organizational right agreement was to end in March. So now, if a union is being refused access while 23 says you must able you can go to court and say that your constitutional right has been infringed. So now 17 says, I want to assemble. So I submit that this is the only way that the applicant can. And I will say that it's quite clear that the action at the High Court, there was no remedy that the applicant can enjoy. And when we say remedy, it must be effective remedy. It must be the remedy that should enable the applicant can have what they have been seeking at the High Court.
Mr. Ravela, if I heard you correctly, in your opening submissions, in response or in respect of jurisdiction, did you submit that the applicant relies on Section 7.2 and Section 38 of the Constitution to found this court's jurisdiction?
As a please, I submitted that it relies on 1723(1), and I also submitted that because their application was brought in 38, in 38 A and E, they rely on the Constitution.
Okay, so it wasn't Section 7, it's Section 17 that you referred to.
17, yes. Right.
Now, on what basis does this court have jurisdiction in respect of the defamation claim?
Well, I will say that Leroux in this court says that the assessment whether the statement is defamatory or not is a constitutional issue. So I will submit that the Leroux Vesta delay tell us that assessment, and Dicolo also tell us that that's a constitutional issue.
So is it your submission that any defamation matter is a constitutional matter?
No, that's not my submission. I'm submitting that if one has to look at the assessment, when we assess whether the statement is defamatory or not, we also have to infuse the constitutional value. So then
if in every defamation case, there has to be an assessment, whether the statement is defamatory or not, there has to be that assessment, then it would follow on your argument that every defamation case is a constitutional matter.
I will submit that if one look at the principle that has been laid by this court in the majority of the delay, this court, Leroux versus delay, this court made it clear that the issue concerning the interpretation and evaluation of an offending statement is a constitutional issue. So,
yes, on that argument, every defamation matter is a constitutional matter. Taking your argument to its limits, every defamation matter is a constitutional matter.
Yes, because it really is about the dignity and so on. But whether that leave should be granted also is another requirement. But I'll submit that yes, it's a it will be. I'll submit that yes.
Now, in respect of appealability, why should exceptions or rulings on exceptions be appealable?
Well, I will simply say that because it is the end is the end of the applicant case in this case. For example, Justice Theron, you will see that the exception on wrongfulness was not pursued at the High Court by the respondents. So in other words, the applicant can able to pursue on the facts that are pleaded the issue pertaining to the to wrongfulness, a cause of emotional shock. But with the order of court that as it stands, they can't simply do that. They don't want to amend, then the court must intervene, because what will happen is that with the order of the High Court as it stands, the applicant, if they don't amend, the respondents will apply to strike out the defense, and then the right to access to court will have been infringed under those circumstances.
Wouldn't the applicants have been better advised in this matter simply to amend than to come to all the way to this court? Wouldn't it just serve their interests better, both in terms of time and money as well?
I will submit that what will they amend if they come to court and say, my Section 23 rights has been infringed, my Section 17 rights has been infringed, and then the court then says, no, my finding is that you rely on Section 12 of the Labor Relations Act, and the Labor Relations Act is not, 12 is not deficient, because the applicant has right, it actually improve that right that they have in Section 17. So I submit that as it stands, there's no amendment that will save this matter as it stands.
Yes, just to finally go back to my earlier question in perhaps a different form. The applicant is pursuing constitutional damages. Do you maintain your submission that there are no other effective remedies available to the applicant?
I submit that there are no other effective remedy available in any state, in the Labor Relations Act, for example. So, because now what we know is that from December up to March, the organizational right agreement was in place. It has come to an end. It has come to an end. Even today, the applicant has not been given opportunity to can meet with its members. One fact that I should also elaborate, Justice Theron, is that we know that this is an essential service workers. We know that for the union to can meet its member at time, it's not something that will be much easier. So now the other remedy that they can do is quite clear, because the organizational right agreement has been cancelled. They are in the process wherein they have to obtain another rights for that. But I submit that there is no other effective remedy that can be better than the constitutional suit and the common law suit of defamation, and as well as emotional shock, especially when that conduct is committed by somebody that we call an organ of state. Who has the right?
Do I understand you to say, Mr. Ravele, that there are other remedies, but they're not as effective as constitutional damages? Is that your submission? Or are you saying there are no other remedies at all?
No, my submission, I say there's two courses of action. There's common law delictual action for emotional shock, there's defamation, and there's constitutional damages. Then what has happened now is that we have the common law emotional shock that has not been accepted. The applicant will really want to pursue that claim because it has not been accepted. We expect the respondent to plead on that. But with an order of court that we should amend while that has not been challenged, the applicant will need this court to intervene to that. So we submit that the common law remedy and constitutional remedies are the only effective remedy, and within the meaning of Section 38.
Thank you, Justice.
And then just to clarify, Justice Theron, there's two things. The common law, the purpose that one will look at is to put the applicant member in the position that they were before the delict was committed. Because we say that we suffer shock. We are surprised that somebody who's an organ of state can come and just say the organizational right agreement has been terminated.
All 540 members. Anyway, you don't need to comment on that, but I just find it quite extraordinary that all 540 members have suffered this shock, but that's not before us. I'm just
But just to follow on that, if there has been a delict, surely the remedies must lie in delict.
Yes, the remedy must lie in delict, but unfortunately, the Mkomape case was not appealed further to this court. We know that there's Tobacale that is before this honorable court. We believe that we're in a delict because the delict will only to put them in their position. But here, they are also asking for further the protection of the Constitution. They are saying that, look, we don't only need this compensation, per se, because if we'll have organ of state that they will do as it please and put falsehood, it might not inspire confidence to the citizen of the country.
Thank you, Justice.
Mr. Ravele, just on one point on this aspect, what about an interdict? Couldn't we have gone immediately to the labor court for an interdict?
I would say that, yes, that could be a remedy, but we must look at the kind of the people that we are representing. An interdict will not give you the damages that you want. An interdict will not protect the Constitution. So it's just temporary measures that you want, but you're still gonna go to the High Court. We don't have funds to do so. And by that time, you might be delayed for 3 months, and when the matter reaches the High Court, the matter is moot.
So you say the Labor Relations Act does not make provision for an award of constitutional damages. That's why you then sought to claim constitutional damages in the High Court.
I'll submit. So I submit that this is so because we want just to look at this way, Justice Mklan. I mean, many organizations get to be told to say, well, you must pay this person this. They will just pay. But a finding that we are looking at, prayer 1 in the amended particulars of claim, the finding that they violated the Constitution is a serious finding, because surely even those who have employed them, the Department of Correctional Service, they will then have to wonder, we are contracted, this person has violated the Constitution. So it has serious impact and it inspires confidence in the South Africans.
I suppose if you are correct, that would mean that what you seek from us is for us to not, because the High Court upheld the exception on that point. What you want is for us to set aside that order, and the High Court will then have to decide whether indeed your clients are entitled to constitutional damage. You'll have to prove that in order to succeed for an award of constitutional damages in the High Court, not before us.
No, not before this honorable court. And then I'll submit that having taken into account in our pleading, in the background facts, we have already shown that the genesis of this matter, we have the respondent who were ordered by their employer to pay the pension of the workers. They just didn't do that. So now we know, when we approach this matter, we know that who are we dealing with? And then that finding is important. And surely that must be determined by the High Court, and the matter can come to this court when the issues have been ventilated. As a
Let's come to the second claim, the defamation claim. At para 34 of the judgment by Judge Homo, he dealt with a defamation claim in this respect. That is when the plaintiff was seeking an amendment of the particulars of claim. The plaintiff set out the reasons or grounds why it alleges it was defamed. In the view of the court, a reader of the pleadings can be able to discern what the issues are that the plaintiff are alleging is defamatory, as well as the reasons why they are as regarded as such. As such, it is a finding of this court that the defendants can plead to what the plaintiff is alleging. The question as to whether the alleged utterances or communications are indeed defamatory should be a matter to be determined at the trial or during a full and proper exception proceedings. Just comment on that statement, and when you do so, take into account what Patuti J said when he now dealt with the exception issue in his judgment.
Justice Mflaga, I will submit that Patuti J, as soon as there was this finding by Homo J, that the respondent can able to plead, simply didn't have with respect jurisdiction to can decide, because what we have now is as if Patuti J was sitting as a court of an appeal. So on that aspect, when another court, a court of the same status, not sitting as a court of appeal, has pronounced in this manner, there was no way that Patuti J, with respect, could have then proceed and decide on the exception. But also, when one look at the test that has been applied by Patuti J, the test that was applied is not the test that must be applied at the exception. The test that was applied is a test that has been borrowed from Leroux when you assess a defamatory statement when there's full-blown trial. So we submit that the correct test on defamation that ought to have been applied under the circumstances is as follows. If the court can just bear with me, it's in our heads of arguments. We submit that wherein the test has to be used is the word might, is not whether the statement will be defamatory. And then we submit that it's quite clear that the court should intervene, because it will not amount to fair trial when in the applicant, another judge has said, no, this is defamatory. I mean, you can able to see that this statement is defamatory. So we submit with respect that it's quite clear that the finding on defamation cannot sit. And we simply say that the court was prevented to make any finding. And more so when, because we know that the respondents were saying that if amendment should not be granted, because if amendment is granted, then the pleadings will remain acceptable. And then now we can see that the amendment was granted. And then the granting of amendment, Homo J will not have granted amendment if the pleading will remain acceptable. And we submit that this court should intervene, because what happened, especially with the defamation claim, it was not a small matter. It was a serious issue that impacted on the applicant right to fair hearing in terms of Section 34.
Just one in this aspect. Didn't Homer J also created confusion, because he grants the amendment, and in the same paragraphs, he then says the defendant may raise an exception. And even in his order, para C of the order, he provides an opportunity to the defendant to set the matter down for the exception. Having said that, there is nothing wrong with the amendment.
I will agree, but it's up to the litigant. It's up to the litigant to really know if we are going to accept, while we know that the general principle is that an amendment which is opposed on the ground that the pleadings will remain acceptable will be dealt with as an exception. So it was incumbent upon the respondents. They are represented, throughout the trial. At the time that they were represented by senior counsel of note, they ought to have known that they cannot vex the applicant in two proceedings, and they ought to have pleaded, and we will not have been in this court. So I agree that yes, there's confusion, but it's the duty of a litigant to interpret the court order, and a proper interpretation of homo juris tell us that you can able to plead, and a proper appreciation of law tell us that when you accept a pleading on the basis that it will remain acceptable, then it is dealt with as an exception, not as an amendment, as a please the God.
Thank you. Thank you.
Justice.
I'd like to raise something with Mr. Ravele.
Sorry, colleagues. Sorry, colleagues. Mr. Ravele, if 45 minutes is up, I know that we never really gave you an opportunity to argue your own case. So how much more time do you think you need?
I don't think it will be more than 10 minutes. I don't think it will be more than 10 minutes.
I'll give you up to the hour. I'll give you up to 11 o'clock.
Thank you, Justice Madam.
Yes.
Mr. Ravele, just I'd like to turn to the Pretorius judgment that you rely on. Now, I know that in Pretorius, the unfair labor practice was invoked in respect of unpaid pension funds from Transnet. And this court held that there appears to be a gap in the Labor Relations Act given that kind of claim. But here, what I want to suggest to you is that there's no gap. And if you can look at the Labor Relations Act, Section 12. Section 12 guarantees trade unions the right of access to workplace. Do you accept that?
I accept it.
If there's a dispute about that right of access, in Section 21 of the Act says a party can refer it to the CCMA. Do you accept that?
Yes, I accept that, but with the qualification that in this case there was no dispute, because there was falsehood that the Augustinal right agreement is cancelled because the Augustinal right has been terminated. So it was not terminated.
We'll get there. We'll get there. Let me just pause there. Do you accept that the dispute concerned whether you have a right of access? The company said you no longer have a right to access, and you say you still have that right of access. There's a dispute. Do you accept that? Just for that purpose.
Yes, I accept that, but I also have to indicate that we should also properly look at this. Also 17, we request to associate. It's a request to say we want to associate, and a further pleading is that please, even after hours, because after hours you don't have control with workers.
Yes, I heard your argument, Mr. Ravele. All I'm trying to establish is that there's a dispute about your right of access, and therefore Section 21 says you can take it to the CCMA. Do you accept that? Just as a matter of principle.
I will say that I will not accept that 21, when I look at it, it's if I can just go to it, it says any trade union may notify the employer in writing that it seeks to exercise one of the following rights. That has been done, Justice Majid. There's an organizational right agreement that right has been conferred already.
Yeah,
so,
but there's
so now,
okay, sorry. Yes.
The union already enjoy that right. And when it has that right, it cannot go to to the CCMA and say, we want organizational right agreement. It has that.
All right. Look, let's move on then. You and I disagree on that one. So let's go to the second point then. Do you accept that this organizational right agreement is part of a collective agreement between you and the respondents? Do you accept that? It's a collective agreement.
Yes, I accept that.
Now, Section 22 says if there's a dispute about a collective agreement about its interpretation or application, that also can be referred to the CCMA. Do you accept that?
Yes, I accept that. But with the qualification that in this case, there was no dispute, because the reason that why we are not allowing you access has been communicated in writing. It's there.
Mr. Ravele, we would not be here if there was no dispute. Please, 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 please.
Well, I'm not going to take it. I'm not going to take it
Continue,
further.
my brother.
Okay.
Sorry.
Just one aspect.
Justice.
Oh, sorry.
I'm not going to pursue it further because, I mean, if you say there's no dispute, then as my brother presiding says, I don't know what we're doing here. So I'll leave it there. I think this has become circuitous and doesn't take us anywhere if you reason like this. But thank you. I have nothing further. Thanks.
Yes. Just a follow up on what Justice Majid asked. You say that the organizational rights agreement was still in existence when, I will say in quotes, the dispute arose.
Yes, I agree with that, Justice Salis.
And the applicants are bound by this organizational rights agreement.
Yes.
And their contention is that it's not terminated, and the respondent says it's terminated unilaterally.
Yes.
But then there's a built-in dispute resolution procedures and mechanisms within the ORA itself. Isn't that the case?
Yes, but I'll submit that does not, if in this case, if one look at the employer, which we said is an organ of state. In this case, we know that throughout until March, when the agreement is terminated, everything in the collective agreement, the union was enjoying, except not being permitted access to its member. But everything, for example, the subscription fees and everything they are enjoying. So now we are saying that because it doesn't matter how angry the respondent could be with regard to the incident that has been pleaded in the particulars of claim, because we know that there was a meeting, some members were then dismissed.
Maybe I should interrupt you. Just want to understand clause 5. What does clause 5.1 says of the collective agreement, page 163?
Clause 5, any dispute concerning the interpretation, application, and termination will be dealt
of this agreement. Termination of this agreement.
Yes.
Will be dealt with in terms of the Labor Relations Act.
Yes.
And then 5.2 says it will be referred to arbitration, and if you are not any party that is not aggrieved by that arbitration will take it on review.
Yes.
I see. No, thank you.
Justice Madlanga, may I clarify something with Mr. Raveli?
Yes, please. In fact, I was coming in to say you were trying to for quite a while.
Mr. Raveli, can I just take you to the particulars of claim which were the subject of the exception? As I understand it, it's at volume 2, starting at page 111. Can you just confirm that is the form, the particulars of claim were in when the exception was taken?
Yes, please, Justice Rogers.
Yes. Then we can see there's some introduction, parties, jurisdiction, background, facts.
Yes.
And the organizational agreement and majority status. And then at page 116, starting at paragraph 17, there's something headed cause of action. And this now deals with the refusal to grant access to the workplace.
Yes,
and that part of the pleading culminates in paragraphs 25 and 26. The defendant's conduct must be declared inconsistent with the Constitution. And 26, the plaintiff is entitled to appropriate relief, and the court must decide, the High Court must decide what that would be. And if we go to the prayers for relief, am I correct that the prayers which are flow from that cause of action are essentially prayers 2 and 3 at page 123? It's declared that the refusal to give access was unconstitutional. And 3, the plaintiff be granted appropriate relief, which may include an interdict or mandamus or such other relief as may be required. That's the relief. Yes. So, so constitutional damages isn't part of that claim.
If one look at,
so I'm going to come to the claim for emotional shock and the psychological treatment, but up to there, that cause of action appears to result in the prayers for relief, which we see in paragraphs 2 and 3.
Yes, please. I agree, because if there was an issue
I think time's limited. So if you don't mind, if we now an interdict or mandamus. Apart from, you've been referred to procedures both under the ORA and under the Labour Relations Act, where disputes about the application of access rights can be referred to the CCMA. Independently of that, the Labour Court has a jurisdiction to grant urgent interdicts under section 158(1)(a), not so?
Yes, I agree.
So the mandamus or other interdict or other appropriate relief, which is contemplated in paragraph 3, is the sort of relief which the Labour Court could have granted on an urgent basis if you were being denied a right of access to the workplace. You know, it's parallel with, and while the matter was being dealt with by the CCMA or in arbitration, you could get urgent relief from the Labour Court.
Yes, but we will not able to get, because it should not be forgotten that one of the prayer that the applicant is seeking is prayer 2, is to declare the conduct to be inconsistent with the Constitution.
Yes, but the Labour Court, if it was going to grant you an interdict, would first have to find that you have been unlawfully denied access to the workplace. And that would be a violation of your LRA rights, which in turn give effect to the section 23 rights in the Constitution.
Yes, but
right.
it could not forge a tool that enforcing. This court has said that an appropriate remedy, the court will look at various circumstances, and then which we submit that it can also look at the constitutional damages.
Well, what prayer 3 envisages as the only relief it mentions specifically is an interdict or mandamus. Now, that seems to me on the face of it to be the most appropriate relief. What you want is access to the workplace. And that is something on an urgent application the Labour Court could grant if it was satisfied you had made out that case.
Justice Rogers, we also 3 also say or such other relief as may require to ensure the plaintiff rights in ensuring the Constitution are protected.
Yes, but yes. Then if we carry on just to understand the structure of the particulars of claim, back to page 119, we have the pleading of the defamation claim, and the prayer for in that respect is prayer 4, the claim for 1 million rand, not so?
Yes.
And then under the heading of emotional shock, starting at page 122, that takes us to the end of the pleading, and that's the subject of the prayers 5 and 6, substantively, the claim for 108 million and just over 1 million rand, correct?
Yes, I agree.
In your heads of argument, you say that the High Court, if I can call those 3 causes of action, the first, the second, and the third causes of action, we have the the denial of access leading to the prayer for mandamus or an interdict or other appropriate relief. We have the defamation claim, and we have the emotional shock claim. In your heads of argument, you say that the High Court didn't decide the third claim. It didn't decide the damages claim. It didn't decide the exception to the damages claim.
So we say that the High Court did not decide the exception on wrongfulness. I think it's a second exception on wrongfulness.
In other words, your paragraph 5 of your heads of argument said for that reason, you would only be considering and addressing the exceptions to the first and second claims.
Yes, because there was no judgment that was given and there's no cross appeal, we submit that the claim in respect of emotional shock at the High Court is still sitting. The common law delict is still there. Yes. But then the difficulties is the order that we should amend while there is a common law emotional shock damages that was never has not been decided on.
So, Mr. Ravelli, part of the reason why I'm asking this is to try to understand whether the question of constitutional damages is on your case, on your argument, an issue before us. Because it seems to me that if you say the High Court only decided the the exceptions to the first and second claims, neither of those involve claims for damages of any kind, except the defamation claim. They don't involve a claim for constitutional damages, do they?
No, they don't. So one will accept that if the High Court says the principle of subsidiarity, the principle doesn't apply, so it means that the reliance on the Constitution, which seek to declare the conduct to be inconsistent with the Constitution, and also for the.
Now an entire hour is up, Mr. Ravelo, but you are mid-sentence. Please continue and please answer the question fully.
Yes, sir, please. Yes, sir, please. So I will submit that one will assume that because the exception number 1 also dealt with the issue of constitutional damages.
Yes, thank you.
So Justice Madlanga, if I can just then make a concluding remarks, I will submit that we should prevail because firstly, we say that the principle of subsidiarity doesn't apply. There's no hard and fast rule. The High Court doesn't even tell us why that principle should apply, safe to say that Section 12 is prescriptive. Perhaps this is a case that the court should clarify as to those who believe that their Section 23 rights has been infringed. Under what circumstances can they approach a court without being at the risk of being told that, no, you have an appropriate remedy that is available in terms of the Act. Then we therefore submit that with regard to defamation, the test that was applied is an incorrect test, and the High Court could not have entertained the defamation exception while taking into account that Justice Homo has already ruled on it. So we submit that we should succeed. And as I've highlighted
we've seen your submissions on Biowatch, and in fact, submissions on everything. Yeah. Anything else you want to say?
I will submit that we should succeed with costs, as I've already alluded in chambers, please.
All right. I heard you refer to somebody sitting next to you. I'm not sure that when you placed yourself on record, you indicated that you are appearing with anybody. You are appearing.
No, I indicated that I'm appearing today on my own, but throughout throughout the High Court, the Supreme Court of Appeal.
Yes.
That will be my submission.
I just wanted to make sure about today. Thank you very much. Thank you.
With your leave, Justice Madlanga, I have 2 small issues to raise, if I may. The one follows from the discussion that Justice Majid had with Mr. Ravele relating to Section 12 and to Pretorius. Do you accept, Mr. Ravele, that Pretorius is distinguishable in that in Pretorius, as Justice Majid had said, they found there was a gap in the Labor Relations Act. But there is no gap, or there should be no gap here, because Section 12 regulates access to the workplace. So this matter is not on all fours, it would seem to me, with Pretorius.
I will agree, but I will also say that this matter is not also in the same position as Sandu. It's a different case altogether. I will submit that the gap is there because no way in the Labor Relations Act, a person who's saying that my right to Section 23 or my right to 17 has been violated can be entitled to an appropriate remedy in the manner in which he can able to, that Section 38 tell us. As a police justice.
Yes. Justice Rogers referred you to volume 2, page 119. You might still have that in front of you, Mr. Ravele. If you could look at that again, please. Volume 2, page 119. And if you could look at paragraph 27.1, the statement.
Yes, I have it.
Organizational rights agreement is cancelled. I have a difficulty conceptually in how that statement could possibly be defamatory. Can you help?
Yes, I will say it's defamatory because it was meant, we need to look at the context in which this statement was made. The context that the statement was made is made immediately after the 16 executive committee members of the union were dismissed. I mean, were suspended at that stage. It's made wherein the person who's making this statement is the same person who have issued a letter saying that I'm giving a notice and the organizational right agreement will be terminated in March. So the person who's saying that the organizational right has been cancelled, because there's a difference between cancel and giving a notice. So this person knows, and we say that it's quite clear that the statement was made to expose the plaintiff to hatred, so that the members of the applicant can terminate the membership with the respondent, so that the respondent should no longer be held to be accountable to the workers' pension.
But then is that defamation? If the statement was made with the intention that the members must terminate their membership with the union, how does that amount to defamation? On your argument, it's possible that the union could have suffered loss, but how does that amount to defamation?
A reasonable person, because this statement has been directed, we pleaded that it has been directed to 540 members of the union. Then one will wonder that the union that last week or last month that was advancing our rights to get the pension, it's been said that that organizational right agreement has been terminated, has been cancelled. You will wonder, that person, and say, why?
Yes, and I will wonder, Mr. Ravele, as to how that constitutes defamation.
Well, I will submit that that will, because the person who has to, the members of the union knows that the organizational right agreement, there's just a notice that has been given. They know that there's a notice that has been given, and they know that the date that this notice will end is this. But now, if they want to access, they say, they are the one who are writing, say, please allow our union members who are suspended access to work. And they are told that no, refused, organizational right cancelled.
Thank you, Justice Madlanga.
Just to follow up, Justice Madlanga. If we find that the agreement was validly terminated, Mr. Ravele, do we ever have to go into the question of the defamation claim?
Yes, we have to go to the defamation claim.
Are you saying that the defamation claim has an origin of its own, irrespective of the recognition agreement and the cancellation of that?
Yes, because firstly, I don't think that this court at an exception level will on an appeal, will able to find that the agreement was valid, correctly cancelled and so on. So secondly, then now, if we are to talk about rights in section 34, we'll be sitting with two judgments of the same court, that another judge has said this, another judge has said this.
So the answer to my question is yes, that we do go into the defamation claim.
Because it's an independent claim.
Okay,
yes.
Thank you. You've answered.
Thank you.
Thank you, Mr. Ravele. Mr. Mutau.
Thank you, Justice Malanga and Justices of the Constitutional Court.
We will
following...
go, Mr. As I indicated to you, colleagues, Mr. Mutau said we can ask him questions right from the beginning. And we will only go up to 15:15, Mr. Mutau, and we'll take a break, a 15-minute break at 15:15. Thank you.
Thank you, Justice Malanga. Following the discussions between the court and our learned friend, we would suggest that in respect of the first claim, the appropriate point at which to start is to have regard to paragraph 17 of the particulars of claim at page 116 in volume 2. And therein, under the course of action, the court will see that the applicants plead that their request that was made during the period of December 2017 was guided by the Organizational Rights Agreement, and it was also made in terms of Section 12 of the Labor Relations Act. And we would submit that that is an important point of premise, because the next point at which one should go in our submission is the point that was raised by Justice Taletsi, which is that if one interprets the true nature of this dispute, the dispute relates to the collective agreement and what entitlements, if any, the applicant enjoys, and in particular, whether the termination of this collective agreement was correctly done or not. And in this regard, page 163, clause 5 of the ORA is of importance, because as you will see in clause 5.1,
please repeat that reference, Mr. Mutau.
It's volume 3, it's annexure MLM 7 at page 163.
Thank you.
Thank you, Justice Malanga. And therein, there are two clauses, 5.1 and 5.2, under the interpretation and application of disputes. And 5.1 provides any dispute concerning the interpretation, application, or termination of this agreement will be dealt with in terms of the Labor Relations Act. And if I can just pause there for a second and deal with perhaps the dispute of whether the agreement properly interpreted entitles the applicant to access to the workplace or not. And with that access having been denied, the dispute squarely falls within one envisaged by clause 5.1. And we would submit that any dispute relating thereto ought to be dealt with in terms of the provisions of the LRA, which is the contractual regime agreed to by the parties. And perhaps while I'm at it as well, I should just deal with a dispute relating to termination. The applicant says, well, it was wrongful for the respondents to communicate the fact that the agreement had been terminated for the reasons that they advance. The correctness or otherwise of those reasons we would submit is not of much importance to the determination of the matter in our submission. Safe to say, it locates the dispute as one of termination of the agreement to which the parties agreed that the resolution of such a dispute also falls to be determined in terms of the provisions of the LRA. And 5.2 then comes into play that any dispute shall, in peremptory terms, be referred to the CCMA in accordance with the provisions of the LRA, and that any party dissatisfied with the outcome of the arbitration has the right to take the outcome on review. But perhaps there is another fundamental point, which is the paragraph that follows next, which addresses the question that Justice Rogers raised.
This is not stopping you mid-sentence, but it's just to say it's 1:15, but please finish the sentence.
Thank you, Justice. The point that Justice Rogers raised with our learned friend to say, well, having regard to the prayers and a mandamus specifically being one of the prayers that is contemplated in the particulars of claim, the second or the third sentence in 5.2 we submit becomes relevant. It says any party can approach any court, including the labor court, for any matter relating to the dispute as provided for in the Labor Relations Act. And this one contemplates, for example, where your remedy of a mandamus would become available, subject, of course, to the bounds of concurrent jurisdiction, where some of the remedies may lie in the High Court under 77.3.
Let's take the adjournment now.
Yes, Justice, we would submit that's the appropriate point at which to stop.
Thank you. Let's come back at 12:30. It's adjourned, colleagues.
Mr. Court, please.
Court will adjourn until 11:30. Please note that during the adjournment, you're welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing commences at 11:30. Should you exit, you may use the same link to rejoin the hearing.
Justice Mhlantla, are you with us? Between my sister Justice Theron and Mr. Zunaid Naidu, can one of you please assist?
Yes, Justice Chitri, are you with us, Justice Chitri?
Justice Chitri was with us now, I thought.
I'm with you, my sister.
Okay, thank you. Justice Mklantla? But if it's only Justice Mklantla outstanding, Justice Madlanga, I think we can start in the meanwhile while Mr. Naidu perhaps checks with Justice Mklantla, because it doesn't look like we have lost her.
Maybe let's just get Mr. Naidu to just please establish. So that if it's only 1 minute or so, Justice Theron, maybe we'll give it a bit of time.
Sorry, colleagues, I was trying to connect. I switched on so many things. Thanks.
That's in order. That's in order, my sister. Thank you.
Justices of the Constitutional Court, all counsel are online.
Thank you. Yes, Mr. Matao.
Thank you, Justice Madlanga. Just to proceed on the scheme of the first claim, it is also important to have regard to paragraph 15 of the particulars of claim at page 115. And therein, the court will find that the applicant specifies the specific clause of the ORA pursuant to which access was requested. And that is clause 6.4. And perhaps just for the court to make a note, the cross-reference to that clause is to be found at volume 3, page 164. The clause is headed access. And we would submit that once the claim as pleaded is properly understood to relate to access to workplace and a dispute relating to the collective agreement, then the provisions of section 12 of the LRA as pleaded by the applicants in terms of the paragraph to which I referred the court earlier, then we would submit that the remedies as contemplated by the LRA, which we set out commencing at paragraph 9.2 of our heads and 9.3, ought to follow. And we would submit that the consequence of following and applying that architecture is that one would have to apply the principle espoused in Sandu, which we deal with in paragraph 11 of our heads, which is that in circumstances where there is a remedy that lies elsewhere, i.e. in another statute, a litigant ought not to be permitted to place direct reliance on the Constitution. And linked to that is the submission we make that if one has regard to the point we deal with in paragraph 18 of our heads with reference to the judgment of Pretorius, one does not find themselves in a situation where the claim is one which is beyond the scope of the LRA, which would thereby justify a departure and permitting direct reliance, as was the case in Pretorius for the reasons that the court outlined. And perhaps the last point to which
what about, Mr. Mutau, what about the quote-unquote complexity that this court refers to in Pretorius about the fact that the Fair Labor Practice rights, at least in 23(1) and 2, as provided for in the Labor Relations Act, aren't mandated by the Constitution, unlike, for instance, 23(5). So the Constitutional Court in Pretoria is about the issue then becoming complex, quote unquote complex. What are your submissions in that regard?
Justice Malanga, we would submit that the appropriate approach is for one to have regard to Section 1A of the Labor Relations Act, which specifically makes provision for or a recognition that the Section 23(1) right is one sought to be vindicated by the provisions of the LRA. So one then, in assessing whether any complexity arises, we would submit any complexity would arise on account of a legislation which would be wanting insofar as protection of the vindication of a right by a particular litigant.
I understand, I may be wrong, I understand the reference to this complexity to, at least in part, to have something to do with the fact that it is not the Constitution that says to Parliament, legislate. Whether or not the legislature has chosen to say, I'm giving effect to such and such constitutional right should therefore neither be here nor there. That's that's how I read the quote unquote complexity, or at least to what I understand to be the underlying basis for the court to say the issue in that context is complex, not?
Well, Justice Malanga, we would submit that properly interpreted, complexity ought to be informed by whether a litigant finds themselves in a position where they would otherwise be left remediless. In other words, if reliance directly on the Constitution were not to be permitted, it would render such litigants without any remedy. And we understand that to be the overall mischief that is sought to be cured. So the proper approach in our submission would still be to the following of the discipline, whether this particular applicant before the court is or has a remedy that is delineated elsewhere. And in this particular case, as we've illustrated, the parties expressly recognize the fact that the right implicated here is one that is governed and or regulated by Section 12 of the LRA.
Is that then, it is taking into account what I've raised with you already, and indeed even your response to my question, doesn't that make this more an appropriate relief type of case that is under Section 38 of the Constitution rather than a subsidiarity issue?
We would submit not, Justice Madlanga, because if one has to look at what is the underlying mischief ultimately that is sought to be cured, and we submit that one cannot escape the consequences of the fact that the underlying mischief is to ensure that a litigant is left with a remedy that has been legislatively provided for. And if one, with respect, loses sight of what the true nature of the right that is sought to be vindicated may be, one would wander, in our respect, into the realms of what does the statement in Pretorius mean insofar as complexity is concerned. But we would submit that that debate does not arise on the facts of this case, given the fact that there is a collective agreement to which the parties give express recognition of a right that is governed by legislation which contains a resolution mechanism, including the ORA itself, which provides for dispute resolution mechanisms. So we would submit as our last submission on under the first claim that if one has regard to the principle in, if I can just in H versus metal assessment, it's one of the decisions to which the applicants seek to rely, or on which it seeks to rely in paragraphs 11 and 12. Also in Pretorius 51 and 52, we submit that there is no issue of uncertainty in the legal position or any factual complexity which would not justify the determination of the matter on exception. So we submit, or we provide both a substantive and a procedural response. And we would submit that in those circumstances, there is no error that was committed by the High Court in determining the matter on exception.
Mr. Mutau,
Yes.
on that aspect,
yes,
what is the test for exception that the High Court should have or did apply?
The test that was applied or ought to have applied is whether the issue goes to the root or the heart of the cause of action. In other words, does it strike at the heart of the cause of action? And in this particular case, we submit that the issue that is raised is one that struck at the heart of the cause of action. And why that is so, it is that the question of the appropriateness of the cause of action that was sought to be adopted by the applicants, i.e. the direct invocation of the Constitution as opposed to invoking the legislatively demarcated provisions and mechanisms through which to vindicate the right, came to the fore. And for that reason, we submit that the striking at the heart of the cause of action was the appropriate test. And because it was implicated, we submit the High Court properly entertained the exception and properly determined it.
What do you say about Mr. Ramvele's argument that because the applicant in this case is relying on section 23.1 and 23.2, it takes it out of the realm of Sandu?
Justice Theron, with respect, we submit that it is not the formulation of the claim that would necessarily take it out of the realm of Sandu, but the substance which requires the careful following of the architecture of the underlying right that is regulated by the agreement that requires that discipline to be followed. So in other words, it is not for the litigant to choose how to formulate the claim with a view to bypass the legislative mechanism that provides adequate remedy, that determines whether or not a claim ought to directly be permitted to invoke the provisions of the Constitution, i.e. 23 and 24. Because we would submit, if one starts from the pleadings and one starts from the nature of the right, the discipline would, in our view, in our submission, require that that architecture is carefully followed to ensure that the principle espoused in Sandu, in other words, one adjudges that principle against a careful assessment of the underlying effectual stratum. And we submit on the facts of this case, as we have demonstrated, it is impermissible for a litigant to deliberately create a scheme that bypasses the express provisions of the agreement that gives effect to that right and plead a right located in the Constitution to justify its direct invocation. As the court please. Then if I may,
before you move away from that point,
yes,
is section 23.5 of the Constitution impacted in this?
If I may, Justice, we would submit yes, and in fact we would have, we make the point in our heads that the union has not pleaded the case of 23.5, which we perhaps could have understood if that had been the case. Not necessarily that it would not necessarily have an answer. But as we understand the right sought to be complained, or sorry, the right which is alleged to be violated, it is one that is enjoyed by the trade union, and it is one we would submit that is implicated by 23.5, which would also require collective bargaining dispute resolution mechanisms to be followed. Because 23.5 in express terms does make provision or envisages that national legislation would be promulgated and or enacted to deal with that. So even assuming that they had invoked 23.5, they would still, with respect, not escape the contours of the section and the discipline that the legislatively demarcated jurisdictional determination of disputes as has been prescribed. So that would be our submission, Justice Chika, on 23.5.
Thanks, Mr. Mikel.
Thank you. Then Justice, unless there are no further questions in respect of the first claim, if I may then just proceed to deal with the second claim and the claim, and that is the claim of defamation. And we know that in terms of what this court told us in Leroux, one has to apply the test using the reasonableness test or reasonable reader of ordinary intelligence and how they would understand the statement.
Thank you for changing to reader. I was about to come in and say, please, not reasonable man. Thank you.
Thank you, Justice Matanga. And in fact, I mean that I wouldn't be doing justice also to the language of the judgment, because the judgment puts it in specific terms that it is the reasonable reader of ordinary intelligence, and the question is whether, as was put by Justice Theron, whether the statement that simply conveys the refusal of the application and the cancellation of the ORA is defamatory, and on what basis. We know that the applicant has pleaded 7 meanings, and those we deal with in our heads of argument at paragraph 28. But we submit that applying the Leroux test to the statement, no defamatory meaning, either on the ordinary reading, taking context, and even its implied meaning into consideration, can result. And perhaps the question that one should deal with is the ancillary question that was raised by Justice Mhlanta. And that is, well, what does Justice Kgomo mean in his findings at paragraph 34? And if I can just go there.
And 39 and 40.
Yes, 39 and 40. Yes. Yes, read with the prayer. So yes. Well, one has to have regard to the nature of the dispute that served before Justice Kgomo. And one will recall that Justice Kgomo was presiding over an opposed amendment application, and he granted the amendment together with costs. And importantly, as part of the findings in 34, 37, 40, and 45.3, the judgment expressly recognizes the fact that it was not determining the executability of the pleadings. And in express terms, Justice Kgomo determined that the issue of executability will be dealt with either at trial, well, the issues once the amendment is granted will be dealt with either at trial or by way of exception. And regard must be also taken of the fact that, or head of the fact that, one of the arguments that was advanced was that the pleadings, even if amended, would still be executable. That was the main contention. And His Lordship, Justice Kgomo, granted the amendment, but with the express proviso or provision that the executability or otherwise was not a matter that was closed. And thus, the issue was ventilated before His Lordship Justice Patuti. And we would submit that the finding in that regard was correct, having regard to the 5-stage test of defamation.
Mr. Matau, on ordinary principles, is an order granting a plaintiff leave to amend his particulars of claim appealable? In other words, an order granting rather than refusing an amendment, is it an appealable order?
Justice Rogers, as I recall, it is not.
Thank you.
And as a consequence of that, I mean, the ultimate issue we would submit is if one has regard to the utility of exceptions, which is to weed out unmeritorious claims, and at least for purposes of formulation, because one heard that one of the contentions by my learned friend says, well, there is a section 34 right, which is implicated if one were to insist on an amendment. And we would submit that is an incorrect submission of law, because the need to plead a proper cause of action does not in any manner, form, or shape infringe and or implicate the right to section 34. And as one would know, if we were in that realm, one would have to deal with whether section 173, which allows a court to regulate its own procedures, even in instances such as security for costs, where this debate ordinarily arises, where people say, well, if you insist on the payment of security by one party, that directly implicates and or violates section 34. This court has pronounced that that is not necessarily so. And similarly, here, the insistence on amendment or on having to amend to plead a proper cause of action, we would submit does not implicate the issue of section 34 at all. And if
just a follow-up, which I think in a sense is related to the question asked by my brother Justice Rogers. I think it's in paragraph 14 of Pretorius, where the court refers in so many words to open quote final close quote and open quote dispositive close quote of discrete issues or claims or whatever the word is in a matter. And I think it's on the basis of the view that the court took with regard to finality and the dispositive nature that in that case
would result.
So a need to entertain exceptions on appeal. Do you want to comment on that? And of course, I will invite Mr. Ravele to comment on that as well.
Thank you, Justice Madang. The one distinction that is immediately apparent is the fact that for reasons that we've already indicated, and I think Justice Theron dealt with it earlier to indicate that here issues of finality do not necessarily result. And you will recall, Justice Madlanga, Justice Theron asked Marlene Fed and said, shouldn't the applicant have amended? Because if they had done so, we wouldn't be here. The time wasted and the costs wouldn't have been incurred. And we submit that illuminates the lack of finality, which is something perhaps that might have been or may have been implicated in Pretorius. That in this case, it doesn't leave the applicants remediless. It is simply an incorrect choice of the cause of action as opposed to the absence of one, which we would submit ought to be taken into account, and why in the circumstances of this case, the question of properly applying the principle of subsidiarity as was consistently applied by the court ought to follow. And for that reason, Justice Malanga, that we submit that is entirely distinguishable, because the absence of finality is an issue that does not arise here. And
sorry, Justice Matlanga, can I just, because I'm now in turn following on what you've raised with Mr. Matau, on the question of finality, isn't the ordinary principle was that refusing to uphold an exception is not appealable? Yes. Because you can still argue the same law point at the end of the case. But upholding an exception is usually final, at least when it is an exception based on a ground that the pleading discloses no cause of action, as opposed to merely being vague and embarrassing. Because here, if the plaintiff says, I want to run a case where I'm directly relying on the Constitution, don't tell me I must go and amend in some other way not to do that. I want to run that case. And the High Court says you can't because of the principle of subsidiarity. If it upholds an exception on that basis, I'm not sure if I was understanding your submission correctly. Do you accept that that is final for purposes of entitling the aggrieved plaintiff to appeal?
Yes, insofar as they insist on not amending and wanting to run a constitutional claim. Yes, on that limited basis, we would submit. Yes, that is so.
Yes, thank you.
Yeah. But I mean, for reasons that we've submitted, it ought not to make a difference, because one has to analyze the true nature of the claim. And as we've submitted before, the applicant's preference of choice to rely directly on the Constitution when that is not countenanced by the architecture of the legislative scheme read together with the Constitution ought to be the governing principle. So in other words, to the extent that the applicant persists on wanting to proceed with an unsustainable and/or a legally uncognizable cause of action, that is a matter of choice. It is not the question, it doesn't point to the absence of legal remedies. And thus, the discipline we would submit that is required by this court as expressly set out in Sandu ought to be applied and cannot simply be bypassed on account of the applicant's own.
Mr. Matao, can I raise something with you in the same connection about Justice Homo's judgment? At pages 197 at the bottom and continuing at 198, the learned judge dealt with the issues to be decided and also with the reasons why you submitted it's acceptable. The particulars would be acceptable even after the amendment. Now, the first point I want to make is that this judgment dealt with your objection limited only to the claim for defamation, am I right?
Yes.
Because he says so at 198, he says you advance the argument that the pleadings after, that's at paragraph 15, even after the proposed amendment will remain acceptable based on the absence of the requirement of the publication of a defamatory statement, and it makes other. So it was limited to the defamation claim only.
Correct, Justice Majid. In fact, I must point out, I didn't argue the exception. It was my learned friend, Mr. Franklin.
No, I take that point. I'm just saying, when I say you, I mean your client, of course.
Yes.
And then at the bottom of 197 at paragraph 13.1, he says what he must decide, Judge Homo says, it's whether the intended amendment, if effected, would result in the particulars of claim continuing to be acceptable, and thus whether leave to amend should be refused. He then finds that it is not acceptable and he therefore grants leave. Am I right?
Yes, Justice Majid, you're correct.
He grants leave to amend. So does that mean that he has reached a final decision that this, as far as the defamation claim is concerned, the pleading is not acceptable?
Well, Justice Majid, we would submit that read in its context, I mean, that the remark to which you directed me ought to be read in conjunction with paragraph 30, the paragraph 43. So am I correct? No, it's sorry, 34.
You're thinking of 34. Yeah, 34.
Yes, 34.
Yes.
Sorry, I swapped the numbers around. It's 34.
Yes.
Because he returns to that issue to indicate what the implications of his findings are. And it's not. Oh, sorry, Justice Majid, I interrupted you.
No, you can finish, Mr. Matao. I'll wait for you.
Yes. I'll say, well, one would understand that the finding is not a model of clarity.
Yes.
But the question we would submit should be asked is the following: whether the judgment contemplates and or makes provision for the respondents to accept once the particulars are amended. And we say in express terms, the judgment contemplates and so finds that an exception could still lie.
Yeah. No, I hear what you say, and I agree with you, and that is where the potential confusion arises, because if you read paragraphs 34 and 39 and 40 of his judgment, then it seems to say that although I've come to the conclusion that this would not render it executable, and therefore I think I should grant leave to amend, he says nonetheless this could still be considered at the full trial or at an exception stage should the defendant stroke respondent here be so minded. So it does lend itself to confusion, and that's why I raised the question.
Yes,
and I think that is, and I think that's the point that you make in your heads. You say that although the applicants refer to functus officio, of course what they mean is res judicata. So
yes.
so that's where the confusion arises for me.
Yes, correct. And sorry to interrupt, Justice Majid.
No, I'm
also
done,
in 45.3.
I'm done, Mr. Mutau, thank you.
Yes, I'm saying also in 45.3.
Yes.
Because then that's part of the order.
Yes. Yes, thank you.
And having addressed all the issues in our submission, I think the one question that remains is that of costs. And our submission in this regard is very brief. It is that if the applicant chooses to invoke the provisions of the Constitution and bypassing national legislation that makes provision, well, perhaps can I just make one step back? So can I just take one step back? If the applicant chooses to bypass the dispute resolution mechanism provided for in the Organizational Rights Agreement, in circumstances where it is conscious of the fact that access was sought pursuant to the right expressly provided for in that agreement, and make specific reference to Section 12 of the LRA, which are the correct...
Your time is up, Mr. Mutau. How much more do you want?
Less than 5 minutes, Justice Malanga.
Okay.
Thank you. If the applicant then chooses to disregard that demarcated jurisdiction or jurisdictional discipline that it ought to follow and chooses to directly invoke the Constitution, we submit that it can't be afforded the protection that was envisaged by this court in Biowatch. So this is ordinary litigation, which is one of many between the parties, and we submit that the ordinary rule of costs following the result should be applied.
Mr. Mutau, I'd like to raise that aspect with you. If we accept that you're correct in this submission you've just made, does that not leave us then with a if the applicant had followed the LRA mechanisms set out in the Organizational Rights Agreement, or then set out in sections 21 and 22 of the LRA, does that not leave us with a bona fide, a genuine labor dispute? And then doesn't Dawkin in the LAC, Zungu in the CC, and recently Masha also in the CC apply then? So if he misses out, if they miss out, the applicants miss out on the Biowatch principle, are they not covered? I almost said captured, but covered by the Dawkin, Zungu, Masha cases?
Well, Justice Majid, isn't there a conundrum that arises because there is no express recognition and acceptance by the applicant that that's where they fall? If they had accepted and they had vindicated the right pursuant thereto, we would submit those principles would apply. I mean, those are well known. But there is no acceptance by the applicant. And we submit, therefore, that protection ought not to be afforded to an applicant that resists the applicability of those provisions.
Well, I must tell you, I'm troubled by that submission, because what you are saying to the court, to this court, the following: you say you wrongly invoked the Constitution, whereas you should have, on the doctrine of subsidiarity, you should have relied on the LRA, and therefore you can't be covered by Biowatch. But if you would have relied on LRA, as we said you should have, then you're also not covered by Doken, Zungu, and Masha. I'm troubled by that, because you're damned if you do and you're damned if you don't. How can that be right? You say it would then be a genuine labor dispute. How come those cases wouldn't apply?
No, perhaps not. So perhaps perhaps I didn't express myself properly. That's not the submission I'm making. The submission I'm making is there's a distinction between a litigant that accepts the applicability of the provisions which would entitle them to protection. In other words, if the applicant, if this was an applicant that accepted the applicability of the LRA provision, and if they had so invoked them, I'm not disputing, or let me put it this way, I'm not submitting that had they done so, they wouldn't be protected by the likes of Zungu. I'm saying the point that I'm making is merely a limited one, that the applicant's resistance to the applicability of that regime is an issue that we submit the court ought to take into account in exercising its discretion on costs. That's the sole limited issue or submission, Justice Majid. I could not say if they had accepted the applicability and they had invoked those, Zungu and Dokin in those cases would not apply. I'm saying there's one distinction, that this applicant resists, with legal advice, resists that regime is applicable, and it ought to have invoked it. And we say that resistance ought to be visited with the appropriate cost order. That's the limit of the submission.
Yeah, thank you, Mr. Matau.
Yes, Mr. Matau, here's a difficulty I have with your initial submission before my brother Justice Majid put his question to you. You are basically saying your reliance on the Constitution is wrong. And because it's wrong, you are not entitled to the Biowatch benefit. Isn't that exactly what Biowatch seeks to shield litigants from? Because if they fail, then it means everything was wrong with what they asserted, but Biowatch shields them. So I don't get your submission.
Well, Justice Matlanga, firstly, we don't depart from the fact that this court has a discretion in respect of costs.
No, before we get to discretion, let's just focus on Biowatch.
Yes. Well, we wanted to develop it commencing from there. Then the next point we would submit on Biowatch. We make the submission relying on the exceptions to Biowatch. In our heads of argument, we say the principle that this court has expressed is not an immutable one, because it takes into account whether claims that are frivolous and unmeritorious ought to be protected. And this court in Biowatch, in express terms, says such cases ought not to enjoy protection. And we peg our submission on the limited point that a litigant that expressly recognizes that it invokes a right that is governed by the collective agreement, and it expressly makes reference to the section of the LRA that implicates those rights, but chooses not to follow the dispute resolution mechanism that is set out therein, ought to be treated differently from a genuine bona fide constitutional dispute, which would afford the applicant protection. That's the limited submission, Justice Matlanga. It's not perhaps as strongly as you've put it. If the court is not with us on that point, then it would follow that the applicants will be afforded the protection.
Thank you, Mr. Mutau. Any further submissions?
Thank you, Justice Matlanga. Unless there are any other questions by the court, those are submissions.
Thank you. Thank you. Mr. Ravele?
Thank you, Justice Matlanga and the justices of the Constitutional Court. I have about only 3 aspects that I need to reply on.
Can you please start with addressing the issue I raised with regard to paragraph 14 of Pretorius, the finality and dispositive nature, and relate what the court says there to whether you can ever talk about finality in this matter, especially regard being head to the issues that some of my colleagues raised. I think Justice Theron and then Justice Rogers taking you to your own relief in the particulars and so on. Just address me on the question of finality and dispositiveness relative to what this court said in Pretorius.
Well, I will submit that is it true that in Pretorius, this court has said that the dismissal of exception does not usually involve a final dispositive pronouncement on legal issue. So, but I will submit that because the issue here on subsidiarity, the same judgment tells us that this issue it's complex. We haven't had a position wherein the principle of subsidiarity has been developed to a point where the inner and the outer counsel have reached a clear delineation. So in other words, you are sitting as a litigant and you look at section 38 of the Constitution and you say this section tell me that if my right has been infringed, I can approach court and ask for an appropriate relief. Then you then say, well, appropriate relief here in this case might involve a declarator of constitutional invalidity. And you are aware that section 38(1) doesn't say anyone listed except wherein there's a statute that has provided remedy. It doesn't say so. So it just says anyone listed. And you also look at what section 57, I think it's 57(2) of the Labor Relations Act says. And then you say, look, there's a violation. All that I have to prove that my 17th right has been violated and there must be justification. So let me proceed on this. So I will therefore submit that because this issue is uncharted terrain, it really required this court to really clarify under what circumstances if you're approaching court, because there's an authority that say a litigant may approach court, and this litigant has done so, and with reference to 23(1) and 2 and 17. So I will therefore say that
if the underlying basis for the claim, let's put aside for a moment the issues that Justice Rogers teased out with regard to what to pray for exactly in the particulars before the exception. Leaving those aside and just assuming that the damages claim springs from your reliance on section 23, 1 and 2 of the Constitution. Now, the underlying basis is fair labor practice, not so?
So please, I agree certainly.
Yes. And the Labor Relations Act does provide for fair labor practices, not so?
I agree.
And our jurisprudence, South African jurisprudence in a broad sense, of course, including jurisprudence of the Constitutional Court, does recognize damages claims that arise from a failure to comply with their statutory obligations, not so?
Yes, I'll submit so, but I will submit that in this case.
Yes, it's a pity I've forgotten the case name now, but there is a matter that the one party at least is Transnet for Mashongwa, is it? I think it is.
Yes.
Where I think, yeah, the Chief Justice touches on this, the last principle I've referred to.
Yes.
Now, if that be the position, is it not so that the applicant could have grounded this very damages claim on the Labor Relations Act as is, with no need to go to the Constitution? Is that totally outside of the realm of possibility in terms of pleading and pursuing the case?
Well, I will submit that they could still.
Let's leave aside your section 17 for a moment and just focus on fair labor practices. Is that beyond or outside of the realm of possibility?
Well, I will submit that I haven't seen a case where in a relief really was sought under Labor Relations Act and then in the High Court, and then there's really an award on that nature. I haven't seen, but I hope it could be possible, but perhaps because this is really an uncharted territory, then I haven't really seen the case wherein one approached the High Court on the basis of violation in Labor Relations Act. I haven't seen that, but I will submit that it should be a
this is in the context. This is in the context of your broader case that the respondents are organs of state. So in that sense, I understand your case to, in a sense, relate to a failure by the organs of state to comply with constitutional obligations. But in this instance, constitutional obligations that have actually been captured by the Labor Relations Act itself. If you are able to succeed when you rely on the Constitution directly, I do not see how logically you should not be able to succeed if you rather rely on the Labor Relations Act. You either have this action or you don't, or not?
I will agree, certainly. I will agree, and also in line with what in Mashungwa, because if one look at the judgment, also there was an issue because it was pleaded in a common law, but when leave to appeal was granted, one of the issue was the constitutional right that the BRASA had as an organ of state.
Then once you agree, that takes us directly to the question of the appealability of this order. You are granted an opportunity to amend. Why not amend? And Sandu is not only about, and other related cases, are not only about, challenge the validity of the legislation, the principle of, but it also says rely on it. So with the concession you've just made, then you could just have relied on the LRA for this relief. If in law you do indeed have this, you are entitled to this relief. So why not amend? Why must this be appealable? Why is it in the interest of justice for us to entertain this at all?
I will submit that it is in the interest of justice to entertain this. I will look at Boysen's case, wherein Ms. Boysen's failed, relying directly on common law. It's a pity. And when one look at the minority judgment by the acting Chief Justice Sondo, he said, if Ms. Boysen could have come to this court and say, my right to Section 12 has been violated, no one will have said, no, leave should not be granted and it's not in the interest of justice to do so. So if one look at what happened to, for example, N versus Smith, wherein there's a majority judgment by Madala, Justice Madala, all those cases, they failed because one thing that was missing in those cases, with respect to my view, they didn't have a declarator that they sought to achieve, because it is in the interest of justice for the applicant to get the declarator that they sought, even if there's no constitutional damages, but because when they get the declarator, the public then gets the faith. I had something that I underlined in that respect, to say that when a conduct is declared to be inconsistent with the Constitution, then it also encourages some moral faith, because this is a case that we know that the respondents on force would just come and say no. And the person who's writing that is the same person who writes the letter. He knows very well that it's not true what he's saying. And I will therefore submit that the importance of this case is a constitutional declarator. Again, it's in the interest of justice, because the emotional shock, the delicate claim is still open. We want to pursue it as it is. Again, it's in the interest of justice. In the principle of finality, it cannot be permissible that we can have two judges of the same division on a similar matter, one saying that no, one saying yes. It's as if the other is sitting as a court of appeal. And without that intervention,
I think,
yes, please. I will therefore submit that the interest of justice warrant that this matter should be heard, and the applicant should be permitted to pursue the claim as it stands. Because what will happen, the fact of the matter will never change. I was trying to look at Ngomane case. Is the Supreme Court of Appeal decision. It was never appealed.
Before you move on, let me just say, if it's either you succeed or you do not succeed on your 23(1) and 2 point, I think even though you are urging us to see 17 as a standalone, the truth really is that your case is more about 23(1) and 2. The 17 is just a tag along. And if you were not to succeed on 23(1), I would be surprised if we could uphold the tag along, the 17. Do you want to make any submissions in that regard?
I will therefore submit that with the principle of Pretorius, then this court tells us that is not really to dismiss, to grant exception on subsidiarity will not be really the cost that one will have to look at, because there's a possibility of evidence being led, and there's no prejudice on the side of the respondents because they will still raise the same issue, but the issue will be ventilated at trial, wherein perhaps one of these days a matter can come from the High Court up to the Constitutional Court on the same principle wherein evidence has been heard. So I will therefore plead with this court to say that this is the matter wherein the factual situation is complex, because we just cannot be told, if this matter is allowed to go to trial, there might be serious violation that can be able to be seen that this is a persistent conduct that has happened for over a long time.
How much do you need?
Well, I think
time is long up.
Yes, just to finish, I will therefore submit that 23.5 is not applicable in this matter. They were not requiring to engage in a collective bargain.
Sorry, Mr. Ravele. Section 158 of the Labor Relations Act. Are you familiar that it provides you with, or provides a court with the power to award compensation in any circumstances contemplated in this act? And then subsection 6, an award of damages in any circumstances contemplated in this act. You're aware of that? And is there some reason why the labor relations remedies under the powers of the court was not available to you?
Because if it's a dispute about collective agreement, that dispute will have to be conciliated. It has to first go to conciliation. It can't go directly to the labor court. And by that time, then the matter will have been rendered moot, because it was only 3 months in this case. It was December, January, March, the organizational right agreement will have lapsed. And hence the manner in which the applicant approached the High Court. And just also to say that Obugu from this court tell us that you can still have the same remedy at the High Court, but under 157. So the last thing that I will want to address, Justice Madlanga, is that the validity of Section 12 or 21 is not at issue in this case. This case is about the right to assemble for purpose of participating in the activities of the trade union. It's not a case about the organizational right agreement. It's a case about we want to assemble inside the facility or outside the facilities for purpose of participating in the activities of trade union. So then I will therefore submit that Sandu case is totally different. And I will therefore submit that the violation of a citizen right may impair public confidence and diminish faith in the efficiency of the protection if those who feel that their rights is violated and approach court, and a principle of subsidiarity at an exception stage get to be raised, and wherein they are seeking for the assistance from court to protect and vindicate their constitutional rights. So I will say that, conclude by saying that the High Court had a duty to consider, to send the matter to trial so that the rights that are infringed can be ventilated. That will be my submission, Justice Madam.
Thank you to you and to Mr. Mutau for your submissions. Judgment is reserved.
Yes, please.
And court adjourned.
The court pleases.